All right. Let me share this with you before I talk about impeachment. Durrell sometimes affords the faculty the luxury of not having a class assignment for the day when they have to give a lecture on the theory that they need the time to prepare. I, of course, didn't bother to prepare, so I used my time by floating in and out, and I learned a whole lot today, which I wanted to share with you because you've been working with the same group for the last 10 days, and you don't know what the other groups are like. So I'd kind of like to tell you what I found out when I'm walking around today. I went into Group A, and you might know these folks socially, but not in a professional context, and I watched them work. So what I walked into is there was a woman named Cheryl, and rather than doing the evidence problems, they were going to establish her as an expert on a guy named Rick. So they're talking about her attending Rick University and doing a doctorate in Rick, and she had diverted her studies and done partial study on a guy named fucking Mark. And basically, these people are really bizarre. So to the extent you're and Rick, what we found out, all the experts, he's kind of boring. So what you want to do is avoid this A group. They're really kind of strange, and I'll be in with you tomorrow. You can get me back for that. From there, say what? From there, I went into the B group, which I was with yesterday, who were just wonderful people, until Millette got with them this morning. And I walked in and heard him saying something about, well, don't be sarcastic. So I immediately turned around and left that room, because clearly I wasn't going to learn anything in there. Then I went into Andy Galvedon's group, which I won't identify because they were utterly boring. I just think I was there 3 minutes. It's probably Andy's problem, because I think the people in the group were nice. From there I went to Findling's group, and on my oath he was explaining to them how he had sex with his wife when she was in her 9th month of pregnancy. Now, what this had to do with the evidence problems was beyond me, but I clarified that it was my child, not his, so everything worked out a lot better. What I learned in the morning, oh, and then in the afternoon I just went over to the office and took a nap because I'd had enough of that shit. What I learned was that there are different groups and kinds of defense lawyers. And by the strangest of coincidences, John Lentine, who is with us from Birmingham, Alabama, in I think the B group, had given me a case to read that had to do with admissibility with respect to Dauber, but there was some wonderful language in it. It was a civil case, and a Justice Neely of the West Virginia Supreme Appellate Court had published this. Right. Certainly, the criminal defense bar is populated in general by 1, high-quality young people who are overworked, underpaid, and suffer from a high burnout rate. That's you. 2, good lawyers who take cases only because they're appointed and forced to do so. And 3, a plethora of marginally competent, bottom-of-the-class nincompoops who volunteer for criminal appointments in order to eke out a meager living in a highly competitive world. This fucking judge knows what he's talking about. But it's not just us. Justice Neely also had some insights with respect to our adversaries. This is from the opinion. Bigger budgets, greater staff, more computers, higher government salaries, increased prestige, and improved job longevity will take all the self-proclaimed righteous, anti-corruption, good government enthusiasts and in the space of 1 nanosecond turn them into salivating whores. I love this judge. This guy's good. All right. Let's talk about impeachment, because otherwise Daryl's going to have my ass. Impeachment is a subclass of cross-examination. It is destructive cross-examination. It is the introduction of evidence intended to have a negative impact on the credibility of the witness against whom the evidence is introduced. The introduction of evidence intended to have a negative impact on the credibility of the witness against whom the evidence is introduced. In other words, it's the kind of cross you do when the testimony of the witness is not consistent with the theory of your case and you can't live with it. It's the do not believe the witness. He or she is a liar testimony. He or she doesn't know what they're talking about testimony. Not all cross-examination is like that. Some cross is constructive. The prosecution puts on a witness. There are other good facts that you want to bring out through the prosecution's witness. That's constructive cross. Impeachment is destructive cross. Impeachment is also the most fun that a trial lawyer can have with his or her clothes on. Because what it is, it's that time when you have another human being helpless in public and you get to humiliate them. Which is why we all went into this business in the first place. There's got to be a streak of sadism in you if you're a trial lawyer. You got to have that killer instinct somewhere in your guts, and what's more fun than showing a cop to be a lying sack of shit? There are different areas of impeachment, and I would suggest that when you're getting ready to do your problems tomorrow, which I think will raise your energy level, this day is the toughest day in the NCDC program. I hope it went well for all of you, but if you're a little tired, if you're a little burned out, if it wasn't as much fun, we all have expected that, because this is just tough stuff, these evidence problems. Tomorrow you should kick back into gear. The cross is fun, the actors will be back, the faculty will set up different kinds of spin and situations. Those of you who are experienced will be able to refine your skills. Those of you who are less experienced will discover some new techniques that you might not have used before and not have tried before that'll enable you to do a much better job. It's going to be perfecting and building on what was done last week when you were introduced to the NCDC method of cross, the controlled cross. So in constructing your problems tonight, or your answers, you may want to use this as a kind of roadmap to identify areas of impeachment. The one that we're most familiar with, and the one that we used most often, is prior inconsistent statements. And that has to do with simply a psychological belief, a construct that people hold, that if you're telling the truth, you're going to say the same thing each time. We know that that's not true. You can be perfectly intending to tell the truth. You can be telling the truth to the best of your ability, and you're going to get things wrong. But because there's a belief that you tell it the same way each time, prior inconsistent statements are a permissible form of impeachment and a very powerful form of impeachment. Kind of a variation of prior inconsistent statements is impeachment by omission, and we'll talk about that in a little bit of detail in the next 45 minutes or so. But what that has to do is if you gave a description, for example, something that should have been in that description was left out. And therefore, there's room to question the validity of the description. The character for truthfulness is something that was addressed briefly in at least one of the evidence problems today, and that can be a basis to undermine the credibility of a witness. Specific instances of untruthfulness is covered in the same sort of way. Of course, prior criminal convictions, there's some restrictions on that with regard to the age. Bias and motive, which are two different things that we'll talk about. Defects in capacity to see, defects in capacity to hear, defects in capacity to remember, and contradictory evidence, contradictions. Now, when you do impeachment, you need to impeach with something, with a document, with a prior statement, something tangible, some hard kind of thing. It is not proper impeachment to say, you're a liar. I'm not. Yes, you are. That doesn't work. That doesn't impeach. You impeach with something. And what you impeach with and how you gather your impeachment material can make the difference between somebody going to jail and somebody going home. That has to do with the completeness of your investigation, the adequacy of your discovery demands, the skill with which you litigate discovery, and the skill with which you find ways to develop impeachment materials that you didn't get in discovery. That's the most important stuff, the stuff that you have to show the witness to be a liar or a fool that the prosecution doesn't know you have. Some of those things are, of course, prior statements of witnesses, affidavits they may have filed, transcribed testimony from other proceedings, guilty pleas, sentencing proceedings, motions to reconsider sentencing, bail hearings, civil actions. I love civil actions, especially if you've got a really dead-bang loser hand-to-hand sale of a cop. Research the cop. Send an investigator down to the courthouse, especially if you live in a community not like New York where there's 40 different courthouses, but a smaller community. Find out if that police officer, as many police officers have been, has been involved in a nasty divorce. See what his wife has said about him in those pleadings. Let them know you're going to cross on that. Let them know that you're doing that investigation. Make it personal. There's 100 and some people in this room. If once in each of our careers we're able to get a cop based on some scurrilous remark that his wife made in a pleading about him being a lying son of a bitch adulterer, that's 100 people that don't have to go to jail. Ooh. Jim! What else is on there? What? Cool. While Jim is deciding whether he wants to either die or fix the machine, see what you can do, man.
There you go.
Millette, how did you do that? Pre-sentence reports, if you can get your hands on them. I'd sure rather litigate whether I can get the pre-sentence report of a rat who's going to testify against my client than the actual facts of the case. You can file motions to get these things unsealed if they're not available as a matter of course. You'll probably lose, but sometimes you might win. Job applications. Now, I'm sure that nobody here ever puffed on a job application, but some people, believe it or not, actually do that. And that's a prior statement that you can use for cross-examination. School records. Can you imagine if I was cross-examining Millette on his diving history? and his relationship with some of those faculty members. We could do fun with that. And it's really as creative as you could possibly be. The point is that you need something, a document, in order to do impeachment. Now, let me give you a three-step program for impeachment by prior inconsistent statements. For those of you who have been cross-examining for years, this may help you understand why it is when you're doing well, and why it is when you've screwed up. For those of you who have not had a great deal of experience, this will give you a surefire method to severely minimize the possibility that you're going to get hurt during a cross, and specifically during a cross using impeachment by prior inconsistent statement. I've got a rule of thumb, and that rule is things don't get worse for my client when I'm the one that's standing up. It doesn't always work out, I confess, but it works out more often than it used to, and this procedure helps. Recommit, accredit, confront. Recommit is nothing more than letting the juror or the judge, the fact finder, know what the hell it is you're talking about. Mr. Witness, on direct examination, you testified that the car was blue. Correct? That's all recommit is, just reminding the jury. What you don't want to do is go through the entire direct examination and have them hear all the bad stuff again. But with this, you know that you've got a document that says that previously the witness told someone that the car was red. So you want to highlight the blue car testimony from trial. Then comes the hard part, the accreditation. The accreditation is about legitimizing the prior statement, showing that that prior statement was made under circumstances where it was reliable, it was complete, it was accurate. This is where they screw us. Because if you don't accredit the prior statement properly, that's when you get the explanations. And I'll talk about that in a little bit more detail in a minute. After the jury's put on notice of what you're talking about by recommitting the person, they're locked in, the car is red, you accredit the prior statement, and only then are you ready to confront the witness with the contradiction. The way we get in trouble, and if you go back and look at your prior cross-examinations that got away from you, the witness started running wild, the witness hurt you, the witness gave you an answer that you ended up in an argument trying to get out from under and lost control, that's going to have happened almost every single time because you attempted to confront the witness before you had adequately accredited the document that you were going to use for impeachment. Juanita Brooks is probably one of the finest among us. She's a lawyer from San Diego. And Juanita explains it like this. It's like leading the lambs to slaughter. They're going to go down this long corridor, and at the end of that corridor, there's an axe that you've got that's going to chop off their heads. But all along the corridor, there's possible doors that they can run out. There's an escape hatch here, there's another escape hatch here, there's another one here, and there's any possibility to escape. If it exists, you can bet that they're going to take it before you get them where you want to have them and are able to drop the knife. What the accreditation concerns itself with is closing all of those doors. And let me explain to you what some of those escape routes are. Why is this statement different? What excuses might the person give you? Well, I was upset when I gave this statement. I was confused when I gave that other statement. I was frightened when I gave that other statement. That's not what I said. Whoever wrote it down got it wrong. I didn't mean that. Those are some of the ways. How do you close those doors? You do it in the accreditation stage. Let's say, for instance, you've got a cop and he's going to talk about the car being red, and in his report the car was blue. No, let's say it's a witness that gave a statement to a cop. Makes it a little more complicated. Witness gave a statement to the cop. You've got the police report. You've got it in black and white. You've got a document. Witness testifies differently at trial. You say to the witness, on direct testimony, you said the car was red. Now, didn't you give a statement to the police? Yes, I did. And I show you the statement. Doesn't the statement say that you told the cop that the car was blue? Yes, it does. Without the accreditation, the witness is liable to say, either blurting it out right then, or at best, or on redirect, what? What excuse might the witness give for there being something different in the statement?
That's not what they said.
Okay. What else? Who else can give me an idea? Yes, ma'am. Cop wrote it down wrong. Okay, all this kind of stuff and whatever else you can think of. So here's how you close those doors. Mr. Witness, you were a witness to this crime, correct?
Yes.
You have to answer.
Yes.
And the police officer came over to you and asked you if you saw the crime.
Yeah.
Correct? It was a robbery and they jumped in a car. Is that what you told the police officer?
Yes.
Now, the police officer made it clear to you that you were an extremely important witness, didn't he?
Yes.
He told you that he needed to know what you knew.
Yeah.
Right? And were you upset from seeing this?
Yeah.
So the police officer recognized that. It was obvious you were upset, right?
Right.
Calmed you down before he started to get into the details so you could have a conversation.
Yeah.
Okay? And you, of course, wanted to be as helpful as possible, and you recalled all the details that you possibly could, right? I'm sure you were. I'm sure you were. And the police officer was sure you were when you talked to Sergeant Dantzler, right?
Right.
And he seemed like a competent police officer to you?
Certainly.
So he told you, just relax, right? Words to that effect. And there's nothing to be frightened of. They've driven away.
Yeah.
Told you he was going to protect your identity,
Yeah.
right? Told you that you probably wouldn't be called to court. He lied to you about that, didn't he? Right? But you're here. So he took all kinds of information from you, correct? He asked you what the people look like. And you told him, I can't tell you, I didn't get a good look at them.
Yeah, that's what I said.
Okay? And he asked you, did you remember anything about them, even just as whether it was male or female, right?
Right.
And you told him, I can't tell you, I didn't get a look.
Yeah.
He asked you twice,
Yeah.
right? So he said, okay, you can't tell me, right?
Right.
And then he wrote something down. You saw him doing that.
Yeah.
Okay. And he asked you where you were when they came running out of the bank,
Yeah.
and you told him where you were.
I told him where I was.
Okay? And then he repeated it to you,
Probably, yeah, I guess he did.
and you didn't correct anything he said.
No.
And he asked you what color the car was,
Yeah.
and you answered him.
Blue.
You answered him.
Blue.
Did you answer him?
Yes.
Okay. And he repeated it to you, just as he had done with the other things?
Yes.
Okay. And he wrote it down.
Yes.
So he wants to wiggle. And now I show you, I may show him the police report document. I may save it for another time and use it as a contradiction. But the point is that I've shut these doors down. Now, can he wiggle? Yeah, maybe. Is it as good as we would like it to be? Never. Does it limit the impact of he's going to want to say, I told him the car was blue and the cop got it wrong? We certainly are in a position to argue. Stronger than we were before. None of this stuff is perfect. You shouldn't walk away from this thinking that it's guaranteed, that it's always going to work every time. What this is about is maximizing your profits and understanding how to control a witness. And that's a way to do it in that regard. Now, suppose you want to hand the witness the document and have him read the contradictory statement. How many people like to hand the witness the document and have them read? 1, 2, 3. How many absolutely don't like to hand the witness the document? Half a dozen. How many make it as an ad hoc decision? Sometimes you do, sometimes you don't. Okay. I forgot your name. John? What kinds of things go into that decision as to whether or not to hand the witness the paper?
I'm more likely to hand the witness the paper if the witness has signed the paper in some way to serve the paper themselves. If they have some sort of a personal connection to the paper rather than just a plain statement that somebody else has written.
Like if it's their handwritten statement.
Correct, or if they give it an initial that, or if I have personal information and have seen them review.
What other factors go into that decision?
Whether or not you want the document.
Rule of completeness. Okay. In New York, we have a rule. And that is, never give the other guy your gun. You know, it's a Manhattan rule. It applies maybe in Manhattan. I think it applies in other places. You don't give your weapon to the other person. What you've got to impeach the witness with is your weapon. So I think that you don't give it up. Now, let me give you the factors that I think. If you let the witness read, the advantage you gain is the ability to argue to the jury, you heard it out of her own mouth. She impeached herself. What more could you want than to hear out of her own mouth what she said differently than what she swore to under oath? That's a big advantage. That's a nice argument at trial. But how about if the witness reads it poorly, either because they can't read or they choose not to read? How about if the witness puts emphasis in the statement in a place that you wouldn't want to put emphasis, or in a place that can slightly alter the meaning? Or how about if the witness starts reading and in the middle of it stops and begins to explain the difference once they realize what the difference is? Has that ever happened to anyone? It's happened to me. And that's why I try not to do it anymore. If you read it, you lose that cool argument of She impeached herself out of her own mouth. But you avoid 2, 3, and 4. You avoid those problems. You get to put the emphasis where you want. You know it's going to be read properly unless for some reason you're slurring your words that afternoon in court. And you can play with emphasis. You're not going to have explanations in the middle of it. So my preference almost always is not to give the statement to the witness, but to keep it ourselves. That's something you may want to play with tomorrow. I think there's opportunities to do that, and you may want to try it both ways. Give the witness to the actors who exist merely, they have no careers, these people. They're really like, you ever see them on a commercial? They're a bunch of fucking losers. All of them. Tell them I said so. Especially that guy Tommy, the one in the wheelchair, is like running the whole thing. Bunch of losers. They exist solely to come here and humiliate us. That's what they want to do tomorrow. So give them the statements and see what happens. They will be loaded for bear, ready to beat you to death with those statements. Let me see. Oh, bad questions, which you cannot ask. Now, you understand that there are NCDC graduates all over the United States. There's hundreds of them, and there is a secret society. They monitor trials in courthouses. No, this isn't a joke. This is serious. I'm not kidding about this. And if you ask any of these 3 questions, then they will come to your house and beat the shit out of you. Bad questions which, if asked, will cause you to break out in a horrible rash and your nose will fall off. Trust me, I wouldn't lie to you. Or in the alternative, they'll come to your homes. Okay? That's not the same thing you told us here today, is it? Okay? Yes, it is, counselor. You're trying to twist my words. That's exactly the same thing, and you're attempting to distort it. Was your memory better now, or is it better? Was it better then, or is it better now? Well, actually, I've thought about it, and my memory's better now. You know, I focused on this and zeroed in on it. Guaranteed it's better now. And, of course, the incomparable why. Ask me why, I'm going to fucking tell you. No doubt about it. You can only get in trouble asking those questions. Impeachment by omission. We talked about that just a little bit before. That is, if it was true, you would have said it before. The problem with this, there's even more potential escape routes. And with respect to whether you give them the document, you can't read what isn't there, or can you? Have any of you ever thought that you were going to be able to do a beautiful, powerful impeachment by giving a witness a document and say, now it's not in this statement of yours, is it, Mr. Witness? And have the witness come back and say, well, matter of fact, here it is. See, if you read this in conjunction with the second line of the 3rd paragraph, it becomes clear that that's exactly what I said. Does that happen to anyone? So, that's the omission. Now, omission has more escape routes. It has, I was upset, confused, frightened, they wrote it down wrong, I didn't think it was important. That's a cop. That's a cop one. And tomorrow you'll work in detail with respect to how to block a cop off from doing that to you. That kind of thing isn't supposed to be in the report. Again, you'll work tomorrow on that. That's the kind of thing you're going to shut off in the accreditation stage. Nobody asked me that, and this is the hard one. Hey, I made a mistake, so sue me. All right? When you've got that coming from a cop, when they're willing to own up and say, I just didn't do it right, but I'm an honest person, take my word for it. Your client told me that he put the gun to the baby's head, pulled the trigger, and then raped the kid. Right? I know I should have written it down. I just forgot to. You know, that's a tough one. That's a tough one. But the others are relatively easy. Character for truthfulness is another form of impeachment which we played with today in the evidence problems. I love the federal rules of criminal procedure. What the federal rules of criminal procedure do is essentially make good evidence out of my personal opinion that I believe that a witness is a lying piece of shit. That is evidence in a federal trial. Or even better, gossip. I know other people that know the witness. We sit around and talk about him behind his back, and it's our gossip, our opinion, that he's a lying piece of shit. That's good evidence in a federal case. We can use that to impeach witnesses, especially rats. Specific instances of dishonest conduct where the loan application says you made a mistake. Marty, this was for another seminar. Misrepresentations on a loan application. That kind of thing. A specific instance which demonstrates that the witness is less than truthful. Remember this, that impeachment goes to the truthfulness of the witness, the character trait of truthfulness when you're impeaching a witness. Or, with respect to an accused, other pertinent character traits. But most often it's truthfulness. I think it's Rule 608. Mental illness. Sometimes, in addition to ourselves and our clients, our witnesses are mentally ill. One of my favorites, and this is not a piece of transcript, but verbatim from a newspaper report, there was a case in New York where a bunch of white kids had attacked a black guy that wandered into their neighborhood and had the audacity to walk down the street in Bensonhurst, Brooklyn. So they beat him to death with a baseball bat. There was a witness named Tig who lived in the neighborhood and testified for the prosecution. And he was impeached on the grounds that he had a long record of psychiatric problems, including visual and auditory hallucinations. He had checked out of a mental hospital 2 days before Yusef Hawkins was killed. Under cross-examination, Mr. Tig denied he was being controlled by helicopters and submarines, insisting it was only the helicopters that held sway over him. I presume that his testimony was discredited by the fact finder. Let's talk about drugs. Does anybody have any? Often in drug cases, you're going to get involved with people who not only sell drugs, but people that use drugs. And their drug abuse, as it affects their ability to perceive and recall events, and that's a key, as it affects their ability to perceive and recall events, is proper impeachment. It has to do with their capacity in much the same way a person's ability to observe because of lighting conditions has to do with their capacity to recall, perceive, and recall events. Here's a technique that I like to use with people who have a history of drug use. You'll note that this is handwritten because what I'll do is get one of those big tablets and I'll write this stuff down and I'll say, Mr. Millett, have you ever used marijuana? How many times didn't you inhale? Let's assume you're going to be somewhat more forthcoming and candid, and you will acknowledge that in your youth, way beyond the statute of limitations, on an experimental basis, and only a few times you had indeed used marijuana. All right? What did it do for you? Now, tell me, how was it great, Vic? How did it make you feel?
It made me feel like I was drunk, but I didn't have any.
Okay. Did it affect your perception in any way? Or and how about colors? Affected the way you heard things? I love that. Did it affect your vision? Did you ever go to a movie stoned on pot? Okay, did you ever look at anything stoned on pot?
Lava lamp.
And what was it about the lava lamp? See, I know, I picked these guys 45, 50 years old, they know what like, wow, brother, what was it about the lava lamp that you grooved on? What was it about the lava lamp? So this drug that you ingested affected the way you heard things, and it affected the way you saw things. Did it have any effect on your memory?
I remember that lava lamp.
How about your short-term memory? He can't win. Almost any juror has some sense that marijuana affects short-term memory. And if he says it affects his memory, we like that. If he says it doesn't affect his short-term memory, we like that as well. Now let's talk about other drugs. How many times did you do cocaine? Okay. LSD, crack, methadone, morphine, Tuinol, Seconal, ecstasy. Okay. So you're just a pothead. And in summation, he will be referred to as the pothead. That's called themes, right? And your key phrases, and you'll go back, and you'll make him into the pothead, and would you convict my client on the testimony of the pothead? Does that sit well with your conscience? You know that what the events that he was testifying about were affected by the pot with respect to his ability to see, his ability to hear, and he denies that marijuana affected his memory. You got a good argument there. More often than not, you'll get these admissions to these drugs. People that sell drugs like to do drugs like to brag about drug abuse. Even more so if they're in rehab. You ever been to an AA meeting or an NA meeting? Just drop in sometime. You don't even have to tell them your name. You just kind of hang around. And if you hang around afterwards, you get these ex-drunks and ex-junkies who frequently love to recount their experiences. And once again, it doesn't always work, but it is a technique, and sometimes you get lucky. And you'll get them almost bragging about the drugs you do, and you just write them down one at a time, the ones that they'll acknowledge, and then when you get a long enough list, you put, I guess there were others. So you can use that as a form of impeachment to establish that the witness, as evidence that the witness is less than credible. Bias and motive, two different things. Bias is a condition of the mind which sways one's judgment and renders a person unable to act in an impartial manner. I don't like you. I'm biased against you. Motive is something different. It's what motivates me to act. I don't particularly like you or dislike you. I don't have any axe to grind with you. I just want my 5K 1.1 letter. That's motive. And boy, how many people have tried a case in the last year that didn't involve having to cross-examine somebody on their deal, that didn't have a rat in it? You haven't tried one case with a rat in it in the last year? One case without a rat. I would think that that's much more common. That's our bread and butter, cross-examining rats, as opposed to the rest of our bread and butter, which is representing them. And it used to be that nobody would admit that in public, and now somebody tells you they don't represent rats, they're lying. There's maybe 3 people in the country, and I think they just get somebody else to do it for them. But that's what our practice is, cross-examining rats. That's a motive cross. I have worked out a scenario which may be helpful to you in constructing the chapters in your cross-examination and in telling the story to the fact finder by way of cross-examination. Here's what I think happens with almost every rat. They had a problem. They were either arrested, facing prison, more likely than not, or they needed money. But more likely than not, they had a problem which was facing many years in prison. And you just established that. You had a problem. They needed a way out because they were guilty. Get them to admit that they were guilty. Get them to admit that they were caught. Get them to admit that there was no way out other than to enter into a deal. With the government, maybe even this prosecutor, your partner in this deal, this contract between you, and that came about as a result of negotiation. You offered something, they gave something. Yeah, I offered to tell the truth. We'll handle that in a minute. The fact of the matter is there was a quid pro quo. There were negotiations, and you entered into a deal. And as a result of that process, you having a problem, you needing a way out, you having no way out unless you could enter into successful negotiations and conclude a deal, you wouldn't be here today. You'd be sitting in a prison somewhere watching the millennium come. Perhaps the next millennium. That provides a bare-bones scenario to structure an impeachment on motive with a rat. Now the deal, and this all have to be fleshed out, the deal is something you bargain for. You give something, you get something. And I love this part just because it's cute. You got it in writing. You got a written plea agreement. Is that because you didn't trust the prosecutor? You had to get it in writing? Did they tell you they wanted it in writing? Was it did they say because they didn't trust you? But it had to be in writing. A handshake wasn't enough because there's distrust here. You got benefits, and there's more benefits than meets the eye. You've got to familiarize yourself with them, explore them. Not only immunity, sometimes money, sometimes visiting privileges, sometimes various kinds of special treatment, at least a chance to lower your sentence. Well, nobody's promised me anything. That's right. All it is your hope, and it's dependent upon their making a motion to the judge, and that's dependent upon them being satisfied that you provided substantial assistance to the prosecution. Your written agreement doesn't say substantial assistance to the pursuit of truth. Your written agreement doesn't say substantial assistance to the court. Your written agreement doesn't say substantial assistance to the jury. Your written agreement says substantial assistance to the prosecution of someone else. And they're the ones who decide, and they're the ones who give you the opportunity for a lower sentence. And that's your kinds of cross. Here's the way Albert Krieger did it with a fellow named Sammy the Bull Gravano. Now, I'm sure you've heard of Sammy the Bull. He's a best-selling author, right up there with other literary geniuses like Marcia Clark. You know, Johnny Cochran's writing a new book in response to hers. It's going to be entitled Marcia Clark and Kiss My Rich Ass. Here's a transcript from Krieger cross-examining Sammy the Bull. You had something else to give the prosecution, correct? Sammy says, my lifestyle. Question, your testimony. Krieger heard McCarthy's lecture about these 1 and 2 words crosses. Answer, yes. You're being a witness. Yes. You're testifying against John Gotti. Yes. And as a result, Mr. Gravano, prosecutors agreed to file an information to which you would plead guilty pursuant to an arrangement where instead of life without parole, you would face a maximum of 20 years. Correct? Yes. That lays out the quid pro quo, the deal. And what's interesting here is that even Sammy the Bull can be trained to give yes answers. And if Sammy can be trained, our witnesses can be trained. You know now he's out. He actually, instead of 20, he got 5. That was their secret deal all along. He's got some plastic surgery, he's got a shitload of money, and he's probably living in a community where he can't be found, perhaps a block away from you. So if you get in a dispute with an Italian guy from New York over a parking spot, give him the goddamn parking spot and pull off, because we just don't know how he's going to respond. Another piece of this is, one of the things you have to deal with is how the rat knows what to say. So you can bring that out. And we know this from our representation of rats. Sir, after your arrest, there were there not, copies of tape recordings turned over to your lawyer, right? Yes. And there were documentation turned over to your lawyer, right? Yes. As a matter of fact, there were tape recordings played at what was called your detention hearing. You know to what I am referring? Yes. The implication is that the guy who starts out as a defendant and later flips has done so after the benefit of some discovery, so he or she knows how to shape their testimony consistent with what the prosecutor will want to hear. The other thing you can use, remember we're using weapons, we're using documents for impeachment, is the plea agreement itself. Here's some language from one of my plea agreements. A sentencing adjustment, if they deny that there were negotiations, the paragraph in the plea agreement clearly indicates that it was entered into after negotiations, that it has to do with the prosecution's acceptance of the testimony. Look at the plea agreement and find the words, and then do that for which people hate us. Manipulate, twist the words, turn them to your own advantage, wrap them in a ball and shove them down the witness's throat. And those words exist. You just have to look at them with an evil, vicious mind. It's easy. It's in all of us. Now, the worst thing is when the bastards go through the if I have to tell the truth, I have to tell the truth routine, which is difficult. But oftentimes in the plea agreement, you find this kind of language which you bring out. If as a result of his testimony, the government is of the view that the defendant has rendered substantial assistance, as that term is defined in Section 5K1. The government will apprise the sentencing court of the nature and extent of defendant's cooperation and that the defendant qualifies for departure below the statutory minimum. And that's the document you use to establish that the control of the witness's life is in the hands of the prosecutor. That's where you impeach them with, I have to tell the truth. Because your deal is substantial assistance to the government. Now, there'll be other paragraphs that have to do with truthfulness, but you're back to who determines that. And finally, I'll give you one little tool because, as I told you, all of this stuff will not work all the time, but most of it works a lot of the time. But let me give you a lock. And this one, I'm about to show you a draft, sample of a letter to use to rebut the I have to tell the truth response which occurs when you're impeaching a cooperating witness. This letter has been characterized by one judge as the most unfair, self-serving, one-sided document she had ever seen, and I think she's right. I think she's right. I certainly hope it is. What you do, and we can get you copies of this for those of you who want to pursue it, or you may want to just draft your own. You send a copy of this letter to the rat through the rat's lawyer. And the letter says as follows. I represent Edward Millett in regard to criminal charges which are pending against him in New York City. In order to properly represent Mr. Millett and to get all the facts before the jury so that they can determine the truth, it is important for me to investigate the case and to interview all of the witnesses. Because you have been identified as a witness, I need to speak with you. My investigator and I are willing to meet with you under any arrangements that you want at a time and place convenient to you. You may refuse to answer any questions asked, and of course, have your lawyer present during the interview. The purpose of this interview is not to embarrass you or to make you feel uncomfortable. I'm closing doors of excuses why they won't meet with me. My only purpose is to have you provide a completely truthful statement of all the facts and circumstances in this case. Although the prosecutors can promise you many things and even help you avoid going to jail for the crimes which you have committed, I can't give you anything for speaking to us. However, since you have discussed this case with the prosecutor and other law enforcement agents, it seems fair that you speak with us as well so that we can determine the truth. Your attorney will confirm that witnesses do not belong to any one side. He or she will also confirm that it would be improper for the prosecutors or agents to prevent or even suggest that you not speak with us. It is solely your decision. It is, however, appropriate to discuss this request with your attorney, and I suggest that you do so. I am so fucking fair. Thank you for reading this letter. I hope that out of a sense of fairness and justice, you will do what is right. I believe that it is right for you to speak with us so that we may be better able to help the jury determine the truth. I hope that after consultation with your attorney, you agree and decide to cooperate with us as you have with the prosecution. Yours truly. Now, you say you only want to tell the truth. Did you get this letter that was sent certified mail to you through your attorney? Pick an answer. No, my attorney never showed it to me. Call the attorney. What attorney is not going to... You got to show that letter. If you get that letter, you've got to show that letter. Have the guy deny that the attorney showed it. Call the attorney as a witness. Attorney-client privilege. I'm delighted to go off into that arena and create all kinds of issues about whether or not the attorney not giving the mail is within attorney-client privilege. I don't want to know the contents of their conversation. Or I did show it, my attorney did show it to me, and I decided not to testify. Fine, you're impeached. You're not ready to tell the truth. You only want to tell the truth to that side. Or after consultation with my attorney, I decided not to do it. Don't tell us about your private conversations, but after discussing it with your attorney, you decided it was not in your best interest to tell me the truth. Or, the one I liked the most, I spoke to the prosecutor and they told me I shouldn't talk to you. That's great. I have never had this letter backfire on me. The worst I've had is the judge flip out and not permit it to come into evidence. The best I had was some schmuck who said that he had spoken to the prosecutor and she had told him not to speak with me, and it was an absolute lie. And she now had, from her witness, had to bring out the fact that he had lied on the witness stand about her being involved, because she knew that, believe it or not, some of the prosecutors think that I'm a bit of a prick, and that if it stood that she had interfered with him in the way that he had described it, there was a disciplinary complaint in the mail the next day. So she had to straighten it out. I won that case too, on the testimony of that witness who put my client in the middle of organizing a heist of Tiffany's jewelry store over Labor Day weekend a few years ago. He got acquitted of that, I think primarily because the prosecutor had to show her own witness to be a liar. So, with that being said, and the fact that it's 10 after 5, I'll close shop. Let's go home. Done.